Hi, everyone, and thank you for joining us today for Effective Workplace Investigations, Social Justice, and Cancel Culture. My name's Sarah Graves. I'm a partner here at Fasken's Toronto Labor, Employment, and Human Rights Group. And today I'm joined by my fellow LEHR colleagues, Katherine Pollock, who's also a partner, as well as the chair of the Partnership Board and chair of the board's Equity, Diversity, and Inclusion Committee. I'm also joined by Cathy Chandler, who's a consultant and paralegal, also in our LEHR group. Before we begin, I just want to go over a few housekeeping matters. Your feedback on this webinar is very important to us. So at the end of the webinar, please click the survey button underneath the video window. Those surveys help us determine future topics, and we really appreciate any of your input. In terms of materials, they are available for today's webinar and can be accessed through the materials button that's also under the video window. We're recording today's webinar, and both the recording and the materials will be emailed out after the event. I wanted to take a minute on behalf of all of us to thank all of you who submitted questions before the seminar. We got so many questions, so many good questions, and in preparing for the seminar today, we made sure that we reviewed all of them and incorporated as many of them in the content of this seminar as we can. But if during the webinar you have other questions, please click on the Submit Question button to send us your questions. We've saved time at the end to answer as many questions as we can. We now have a closed captioning feature for the webinar. So if you would like to turn that feature on, please use the CC button in the bottom of the video window. If you need any technical support during the webinar, please click the Tech FAQ or the Tech Support Chat button, and one of our techs will be sure to help you. If you're looking for COVID-19 specific information, and a few of the questions were, we have a wealth of information in our COVID-19 Knowledge Center, which you can find at fasken.com. And last but not least, and related to the COVID topic, our next webinar is going to be held on June 22nd, beginning at 2 o'clock Eastern Standard Time. And the topic is going to be returning to the workplace. You can visit the Fasken Institute on fasken.com to register for that event and for information on all of our upcoming seminars. We've got some really good ones scheduled that are responsive to the feedback that we've gotten in previous surveys. So let's get started. I mean, over the past few years, we have seen a number of social cultural movements that have resulted in an increased national conversation about issues such as sexual harassment and systemic racism. We've seen an expansion in our understanding of what can be discriminatory, discussions of topics like unconscious bias and microaggressions. And we've seen an increase and a more concrete commitment to diversity and inclusion. So as labor and employment lawyers and investigators ourselves, we've seen this discussion impacting our clients' workplace, as well as the workplace investigations that are taking place. So we thought that it would be useful to look at the topic of conducting effective investigations in that context, to discuss some of the trends we're seeing, things for you to think about, and some practical ways to ensure that your investigation and workplace culture reflect these current discussions and understandings while still complying with expectations around procedural fairness. So we've got a pretty full agenda today. We're going to start with a federal law update regarding the requirements around investigations of harassment, sexual harassment, and violence. We're going to look briefly at investigations and COVID and what we're seeing in that area. We're going to review the topics of unconscious bias, microaggressions, and cancel culture, just so that we're all using and understanding the same vocabulary. We'll look at some recent case law developments that show that judicial understanding and decision maker understanding is expanding. And then we'll look at the impact of various social movements on workplace investigations that we're seeing, including some misconceptions in sexual harassment cases. And we'll finish with some takeaways. So now I will turn it over to my colleague, Cathy Chandler, and she'll speak to you about the federal law update.
Thanks, Sarah. Just get you to go to the next slide. Perfect. So before we get into some of the other important topics that we're going to be discussing in today's webinar, we wanted to provide a brief legislative update that impacts federally regulated workplaces and how these workplaces prevent and manage workplace harassment and violence. As of January the 1st, 2021, federally regulated employers are subject to enhanced obligations to protect their employees from workplace harassment and violence, further to the Bill C-65 amendments to the Canada Labour Code. And these requirements are set out in a new regulation called the Workplace Harassment and Violence Prevention Regulations, which is made under the code. One of the C-65 amendments was to introduce a definition of harassment into the code for the first time, replacing the current definitions of sexual harassment and workplace violence into a combined definition of harassment and violence. As you can see from the definition on the slide, employers now have a positive obligation to protect workers, not just from workplace violence, but from workplace harassment as well. And this includes sexual harassment as well as psychological harm. There are a number of new obligations set out in the regulations, including an expanded and arguably complex incident resolution process that we'll discuss now. Next slide. These are the main steps in the new complaint resolution process. The first thing to note is that the regulations require that the employer designate a person or work unit as the designated recipient to whom notice of an occurrence may be provided. And for most employers, this is likely going to be somebody in your human resources department or your labor relations department. Upon receiving a notice of an occurrence, the designated recipient then has 7 days to contact the complainant, and the complainant is referred to as the principal party in the new regulations, so we'll use that terminology, and essentially inform them that a notice has been received and of the steps that are involved in the resolution process. So this is essentially the start of what the regulations refer to as negotiated resolution. And this is where the employer is required to make every reasonable effort to resolve an occurrence, and those efforts need to begin no later than 45 days after receiving a notice of occurrence. Negotiated resolution is really a form of informal resolution where the principal party meets with the employer or the designated recipient to discuss the occurrence and attempt to reach resolution. And it's mandatory for the employer and the complainant or principal party to make reasonable efforts to resolve an occurrence before the matter is referred to an investigator. And negotiated resolution can continue throughout the resolution process up until the point that an investigator has provided the employer with a report. At that point, the negotiated resolution stage would be over. And I think that the language in the regulations suggests that the employer has some flexibility in terms of what the negotiated resolution process might look like. But at minimum, it would mean meeting individually with the parties to better understand the basis for the complaint or the conflict. Or if appropriate, it could also mean facilitating a discussion between a principal party and a responding party to attempt to come to a resolution. If an incident isn't resolved by way of negotiated resolution, the principal party and the responding party can attempt to resolve the occurrence by conciliation if they both agree to engage in the process and on who will be the conciliator. The regulations don't specifically define the term conciliation, but mediation, for example, could be one form of conciliation. Conciliation isn't permitted if the matter is being investigated and an investigator has provided their report to the employer. And you may want to consider creating a list of potential conciliators to have ready to provide to the parties should the parties choose to proceed by way of conciliation. And finally, if the incident can't be resolved by negotiated resolution or conciliation, then it can be resolved by investigation if the principal party requests it, at which point the employer must provide the principal party and the responding party with notice that an investigation will be carried out. And in terms of timelines, the employer has 1 year in which to complete the resolution process, and that includes implementing recommendations from an investigator's report that have been jointly agreed upon by the workplace committee. So just to summarize before we move on, the regulations allow for negotiated resolution, conciliation, and an investigation to run as parallel processes. However, once the investigator's report is provided to the employer, the occurrence can no longer be resolved through negotiated resolution or conciliation. And the idea behind this is to allow the complainant or the principal party the flexibility to pursue multiple parallel avenues of resolution. So other changes brought by Bill C-65 relate to the competency requirements of investigators. There are increased competency requirements for the investigator, such as having to have knowledge, training, and experience, not just related to workplace violence, but also related to workplace harassment as well. And there's also changes to the process used to select investigators. So investigators can either be selected from a list that the employer and the applicable partner have jointly developed. And under the regulations, your applicable partner is going to be your policy committee. If you're not large enough to have a policy committee, then that would revert to your workplace committee or your health and safety representative. And if no list exists, then an investigator can be selected by agreement of the employer, the principal party, and the responding party. And finally, if there is no agreement on an investigator within 60 days of an investigation notice being provided, then a person identified by the Canadian Centre for Occupational Health and Safety may be selected. The CCOHS maintains a roster of investigators on their website. And the last time that I checked, there were about 73 harassment and violence prevention investigators listed on their website. If you do currently have a roster of investigators, you might want to review it with your policy committee to ensure that the investigators are meeting the new competency requirements. Also under the regulations, the employer has to provide a copy of the investigator's report when it's completed to the principal party and the responding party, but also to the workplace health and safety committee. If you don't have a workplace health and safety committee, to the health and safety rep. So therefore, an investigator's report must not reveal directly or indirectly the identity of persons who are involved in the occurrence or the resolution process. The report should, however, contain recommendations to address the occurrence, to eliminate or minimize risks of workplace violence and workplace harassment in the workplace. So, for example, recommendations might include ways to eliminate systemic issues that might be related to organizational culture or structure, or recommend specific training that should be undertaken by the involved parties. Under the regulations, the resolution process is considered complete once the employer implements the recommendations in the investigator's report. The employer must reasonably attempt to come to agreement with the workplace committee regarding which recommendations to implement. However, the regulation does provide that if these parties can't agree, then the employer's decision on this matter prevails. However, the employer would be required to record their reasons for making their decision and keep a record of that for a period of 10 years. Workers would still be able to follow the internal complaint resolution process that's outlined in the code. They'd be able to file a grievance or file a complaint under the Canadian Human Rights Act if they felt that an employer's decision to not implement a recommendation was a failure in some way to protect their health and safety. And finally, there is no appeal process under the code or the regulations if a party isn't satisfied with the conclusions or recommendations in the investigator's report, or otherwise believes that the investigation is flawed in some way. However, the parties may be able to request a judicial review of the investigation, although obviously we don't have a lot of jurisprudence on that under the new regulations at the moment. So certainly lots of changes under the new regulations. If you haven't already done so, if you're a federally regulated employer, this might be a good time for you to review your policies and your protocols regarding investigations to ensure that they're complying with the new regulations. And I would also refer you to the Workplace Harassment and Violence Guidelines, IPG guidelines, and these are available on the ESDC website. Pass it over to Catherine to continue. Thank you.
Thanks very much, Kathy. Just wonderful to distill that complexity into 3 slides. That's quite a feat. So thank you for that. We just wanted to briefly touch on investigations in the era of COVID. This is something that's new during the pandemic, obviously, COVID-19. At the beginning of COVID, we saw an initial hesitation and reluctance on the part of employers to do anything that would involve, a Zoom investigation or a Teams or any kind of video, and not an in-person investigation. It's fair to say, I think, at the beginning of COVID, that most investigators, including myself, thought you can't do an investigation that is not in person. As the pandemic carried on, however, for a period of, perhaps by the second or third month, wherein it was clear that we were not going to come out of the woods anytime soon, and that there were issues that were occurring in workplaces that required investigation, we needed to shift gears and think about doing investigations through Zoom and other mechanisms. And since then, and with the benefit of hindsight, we've noticed some pros and cons to the whole process. What hasn't changed, though, importantly, is whether you're conducting an investigation through Zoom or otherwise, what hasn't changed is the requirement that the investigation be prompt, that it be thorough, and that there be procedural fairness afforded to both the respondent and the complainant. COVID-specific investigations on Zoom, though, we think some of the pros are it's probably less costly for the parties, in large part because of, we think, travel time. Investigators can just sit in their homes and or offices to conduct the investigation. Parties and witnesses are not required to travel, and so there's that expense that is erased. Next slide, please. Some other pros. We've really noticed that witnesses have told us and have told other people who have prepared reports and so on that they feel much more comfortable when they are able to be either a witness, or if they're the complainant or respondent, to sit in their home, to be surrounded by that which comforts them, as opposed to marching down to the boardroom at Fasken, or having to go to a boardroom at a hotel, which can be quite intimidating. So we believe that is, we're listening to people talking about comfort. One of the issues we've been worried about, and I have this on the con side as well, but is how do we assess credibility? I think that was a main concern when we were worried about going to Zoom in the first place, is how on earth can we assess credibility when we can't be in the same room with somebody? We can't look at how they're reacting. How can we assess credibility? I read an interesting report by Barry Fisher, who is a well-known Toronto-based mediator, and he was talking about assessing credibility in the context of mediation, but I think the same applies in the context of investigations. And he said he thought that, in fact, Zoom was very good at picking up on nuances, in getting to know the person. He didn't view it as a barrier. So his point was that he didn't think we were losing anything in that regard. And it's also a good reminder to all of us who are investigating these things not to look at unreliable nonverbal cues in any event when we're assessing credibility, but rather to focus on the content of the response. Does it make sense? Not, does the person's eyes averting or those other sorts of unreliable nonverbal cues. So to be in the room with somebody is perhaps not as important. Next slide, please. But that said, I think there are some definite negatives to investigations in the era of COVID that take place on Zoom. One of them is connectivity issues. We don't all have perfect Wi-Fi, and in fact, some folks don't have access to Wi-Fi at all. So we can't make an assumption as investigators that when we're meeting with witnesses or others, that of course they'll have a computer that will have great Wi-Fi, and that person will be able to have a private spot in his or her home to engage in a discussion or an interview without distractions from kids who aren't in school and so on. So I've certainly noticed some connectivity issues, particularly when folks are outside of the major metropolitan areas, and household distractions, everything from dogs going crazy because somebody's knocking at the door. Those are manageable, of course. Another issue that we've identified as definitely, I think, a con is it's hard to know who else is there. We would certainly want to ask the person who you're interviewing, just make sure you're there by yourself. But the reality is, if somebody wants to have somebody, stage left whispering answers, we can't guard against that because we can't see anything other than what is on the screen in front of us. I do believe, contrary to Barry's report, where he thought it was okay on Zoom to build rapport and it wasn't a barrier, I believe, based on my experience, that building rapport is more difficult through Zoom. That there is a barrier of a screen. The more you meet with somebody, sure, over time you build rapport, but not to have that face-to-face interaction, I think, is a definite con. There are issues with respect to documents as well. When you're conducting an investigation, you want to have access to all of the documents that are going to be relevant, all of the texts, all of the WhatsApp messages, all of that stuff. And when you're in person with somebody conducting the interview, it's much more likely that the individual will have that stuff with him or her. And when you're on Zoom, it's the materials are not necessarily there. It's often the case when I'm interviewing somebody that they'll remember a text or that they'll remember an email and they'll go to it then and there, and you can see it. Finally, privacy issues, accidental sharing of screens can happen from time to time. And that is something that can't be avoided in this Zoom area. So just in terms of best practices, we're still in Zoom. It doesn't look like we're going to be out of it anytime soon. Make sure that when you're meeting with witnesses, that you ensure that they have a good Wi-Fi connection and that they can meet with you uninterrupted as much as possible. Make sure that they're going to be there with all relevant documents and that there's a way for you to either screen share or to get access to those documents. Make sure that the person is there alone, that there's nobody else in the room there helping them along. And as always, impress on individuals the importance of confidentiality. And just finally on this, investigations in the era of COVID-19, I hope, we all do, that we're going to be out of this very, very soon. And what will be interesting to us is to see what will happen post-COVID-19 with respect to investigations. Will we conduct investigations through Zoom? Will we revert back to in person? Will it be a hybrid where you meet in person with the complainant and the respondent, but perhaps with witnesses you meet through Zoom? I suspect it will be a hybrid approach. Sarah, over to you on the biases.
Thanks, Catherine. And in terms of COVID investigations, we've been in interesting situations where we're investigating sexual harassment that has occurred on Zoom and through the Zoom medium in an investigation that takes place in Zoom. So that's a unique situation that I don't think any of us ever thought we'd be in. So let's talk about unconscious bias and microaggressions. Catherine and I and Kathy thought that it was important to review these concepts, starting with unconscious bias, so that all of us can make sure that in the workplace and when we're conducting investigations, that we look at what we say and what we do in a more thoughtful manner, and make sure our employees are trained regarding these concepts so that we're not either ignoring something that we should be aware of when we're conducting an investigation, for example, or employees are not making others feel unwelcome or creating a toxic environment because of things like microaggressions. So we'll start with unconscious bias. So our biases are opinions that we form about, for example, people or things that are based on our personal experiences, what we've heard from others, whether that's friends or social media, or the news, institutional influences like church or family, as well as our culture and our upbringing. And it's important to know that all unconscious bias does not necessarily equate to racism or prejudice. They're not the same things, but our unconscious biases are often incorrect. So when these biases become ingrained in our mind and in our thought processes, we can not even be aware that they're influencing our decisions or our actions. Next slide, please. There's explicit bias and implicit bias. So explicit bias is a bias that you show as a result of a conscious and deliberate thought. What we're talking about are these implicit biases that, as I said, may be a result of past experiences, expectations, or stereotypes, where we form an opinion in our mind that is often involuntary. Next slide, please. So as I said, these are automatic, unconscious, often unintentional, and people don't even realize that they're making unfair assumptions or basing a decision on a stereotype. And examples often implicate areas such as gender, age, ethnicity, or cultural biases. And there's lots of different types of bias, and I'll just go over a couple of examples just so you get an idea. One is affinity bias, where you unconsciously prefer people who share qualities with you or someone like you. So, interviewing people from your school or people who share hobbies with you or live in the same neighborhood. There's a beauty bias where we may, for example, unfairly favor, believe, or be less suspicious of people who are more attractive. I mean, these are things that psychological research has all shown. There's a confirmation bias, which is also important when it comes to investigations. And that refers to how people search for pieces of evidence that back up their opinions rather than looking at the whole picture. So that predisposition to seek information that confirms what we already think can lead to a reinforcement of stereotypes and can lead us to overlook information and instead focus only on the things that reflect our views. Next slide, please. So the key thing that we need our employees to be aware of, and we'll talk about training a little bit later, as well as that we need to be aware of ourselves when we're conducting investigations or supervising investigations, is we need to be honest with ourselves and think about unconscious biases that we may have. And by identifying and understanding them, we can better address them when they surface. So we can manage them and we can lessen their impact on others. Because if you have certain unconscious biases that remain unchecked, then it can result in certain groups being systematically favored, for example, over others. A key is to avoid snap judgments and base decisions on facts and observations, Be intentional about the information that you're processing and decisions that you're making, and ask yourself, why am I making that decision? That would come into effect, for example, when you're doing hiring. And it also, in many of our clients who are in the retail sector, is important for those who are involved in loss prevention to be aware of. So that if they are basing decisions in their loss prevention activities, they are not engaging unconscious bias when they're making decisions. What we really want to do is practice disciplined decision making and be aware of what things that we are considering to be relevant. So now I'll turn it over to Catherine to talk about microaggressions.
Right, and I apologize if there was choppiness. Hopefully, in taking off my my fancy AirPods, people can hear me better now. Microaggressions, part of a change that Sarah, Kathy, and I have noted, along with the rest of our group in 2021, is how the language with respect to unconscious bias, microaggressions, has made its way into our everyday discussions about what is and is not acceptable in the workplace. So, for example, just recently, a client had pointed out to me a letter that was published in a magazine in the US, and it was a letter, and I won't name the company, but it was a letter by two individuals who left a quite well-known company in the US and stated that they had endured rampant microaggressions, countless microaggressions, and that they were resigning as a result of that. So the language of microaggressions, I think it's important for us as investigators and HR experts to understand what is meant by the term microaggressions. The definition we put up here is behavior or communication. It can be spoken, it can be unspoken, that feeds into stereotypes. A microaggression can be intentional. A microaggression is often unintentional. But we know from the case law and everything to do with harassment, intention doesn't matter. What matters is impact. But microaggressions do tend to be unintentional, or they tend to demonstrate an unconscious bias or stereotyping, sort of looping into what Sarah was saying a moment ago. How people experience microaggressions is often as racism or sexism, ageism, or ableism. These are slights or indignities or put-downs that tend to be experienced on a day-to-day basis that can make the workplace feel very uncomfortable, unsafe, and toxic for those people who are experiencing microaggressions. Next slide, please. Thank you. I think the key in understanding microaggressions in training people is that people are often unaware at the workplace that they have engaged in an offensive or demeaning way. Again, intentionality is not what's at play here. It's making people aware of offensive or demeaning language, frankly. Microaggressions are often communicated through language. And so it's a reminder to all of us when we're at work or anywhere, frankly, to pay attention to how we talk and what we say in the workplace. We know with respect to work that's been done on microaggressions that people who are on the receiving end of a microaggression will feel that they've been insulted or that they're on the receiving end of racism or sexism as indicated, but they don't know how to respond. And I think what is incumbent upon employers is to be sensitive to those recipients and to find a way to educate the workplace so that microaggressions are not a part of the poisoned work environment. Some examples of microaggressions. Next slide, please. These are some taken from an article, and we've added a few here and there. But I think this gives you an idea of what we're talking about. Where somebody, for example, says to a person of color, "You are so articulate." On its face, that looks like a compliment or sounds like a compliment. But spoken to a person of color, the inference arguably is that I didn't expect you to be articulate, and I'm surprised that you are. That's a microaggression. Or to say to somebody who is transgender, "You don't look like transgender," or "You don't look like it at all." That is a microaggression because arguably you are suggesting to the transgendered person that there's a specific way that they should be looking and they're not. And that can be taken as offensive, or something that I'm quite familiar with, where somebody will say, "You don't look like a lesbian." The implication being that a lesbian looks a certain way. Again, there's an underlying aggression to it. To say, I'll just skip down to, for example, to say to somebody, "Where are you actually from?" on its face is not necessarily offensive. You're just being friendly and you're just wondering where somebody's from. But the implication is that the person is not from Canada. Where are you actually from? Where are you originally from? That can be a microaggression. "Are you in the right room?" is a comment taken from an interview with a woman who's an engineer at Microsoft. She was attending a math, she was attending a lecture on math over the lunch hour, and she walked into the room. There were a couple of men there who said to her, "Are you sure you're in the right room? There's a lecture on design next door. That's no doubt where you want to be." The men, thinking they were being friendly and helpful, that was a microaggression, in that there was an assumption that the woman was not in the right room, that she couldn't possibly be interested in in math. Final example, this was the New York Times reported that the number one microaggression in the United States at the moment is, sorry, gentlemen, men interrupting women and saying what they think, and not allowing the woman to talk. That there's no intentionality to be rude, but I'm thinking that interruption, it is, as I say, the number one microaggression noted. The fact that it's often the case that the person who said or did one of these examples didn't mean offense, but the reality is that in most of these instances, offense could be taken. And really the remedy, I think, for employers is to train employees on microaggressions, to train people to be thoughtful in their comments, and to think before they speak. Next slide, please. I think this is a quote that Sarah shared with me yesterday, and we loved it and wanted to put it up. It's just a reminder to all of us to have some empathy, radical empathy, as in a book I'm just reading right now, to remember that when we're talking to people or debating a person about something that affects them more than it affects you, remember that it will take almost certainly a much greater emotional toll on that person. It's not an academic exercise. For them, it feels like revealing their pain, only to have you possibly dismiss their experience. The fact that you might remain more calm under these circumstances is a consequence of your privileged position, not somehow increased objectivity on your part. So we're just asking people or suggesting the importance of training employees on this kind of empathy, to think about the microaggressions that might be percolating in any workplace, because we are seeing a surge, I think, or an expansion in what people believe is discrimination and what people are complaining about. And as investigators, we need to be up to date as we possibly can to ensure that our workplaces are safe. And just a final point, and on the next slide, right, sort of think we've said that in a way, think before you talk, be mindful of different perspectives. And then the next slide, our slide on cancel culture, we did want to reference this, not in the same breath exactly as microaggressions, but it's all of that same piece of unconscious bias, microaggressions, cancel culture. All of this is very relevant to our workplaces today. I was involved in an investigation a few weeks ago where the individual in question, who was alleged to have stated some unpopular, arguably offensive remarks, suggested that he was being canceled, that he was part of this cancel culture for expressing an unpopular opinion. And you'll see on the slide, that's sort of the definition that's maybe percolated up more recently, a counter movement in which people are perceived to be punished unfairly by what they refer to as a cancel culture for expressing unpopular opinions. In my instance, the respondent was saying, don't I have the right to free speech and to express myself however unpopular my opinion is? And this complaint is trying to cancel me out. To flip to the top definition, this was really canceling was the term that was popularized, especially by Twitter users, almost as a form of boycott of individuals or companies who are themselves engaging in behaviors or somehow expressing opinions in conflict with an evolving social landscape. So canceling was meant really as a public call for accountability, and the consequence being essentially a boycott. It has sort of mortified or transformed itself into a broader cancel culture, being something that we're seeing certainly in the U.S. Amongst populist politicians who, whenever they're taken to task, are told that they're being subjected to a cancel culture, and it's not meant to. Cancel culture is not meant as a compliment. But again, it's something that we think it's important that investigators and employers across Canada be aware of and familiar with as a term, in terms of part of your training, to make sure that folks are up to speed on this latest language. And Sarah, we were going to shift over to look at some case law.
Topic of microaggressions. So many employers now are actually including concepts of unconscious bias and microaggressions in their training. And one of the things that we always include, or at least I include when I do training, is to point out to people that you may have just said on one instance that something like, "You're so articulate." But to Catherine's point, that it's the impact, not intent, that's important in the discrimination case law. The person who's hearing that has probably heard it 100 times. So it's the cumulative impact, and that very often resonates with employees. But to switch topics and talk a little bit about some recent case law, I think we can all acknowledge that statutes and case law often lag behind, the developing social discussion, social understanding, and that this area is no different. What we're seeing is that there are some shifts in the way courts and adjudicators are understanding these issues, and we'll go over a couple of examples in a few minutes. One thing that we've noticed that we thought it was important to bring forward is to remind you that, dated precedents are just that. They can be dated. If you are reviewing case law, especially in the area of sexual harassment, discrimination, racial profiling, the precedent may be just completely outdated. There was a Court of Appeal case in Alberta that talked about an arbitrator's reliance on some outdated precedents. and noted that an arbitrator should consider whether time and changing social values would reveal precedents to be based in faulty assumptions, and in this case, about acceptable sexual conduct in the workplace, and noted that the fact that the arbitrator had relied on two outdated precedents in this regard made the award unreasonable. So just be mindful when you're using precedents that are older of that principle. But as I said, there are some recent cases that have shown this development. Next slide, please. So the Levi case is an arbitration decision where there was a verbal altercation between two coworkers, with a white employee aggressively directing racial slurs towards his Black coworker for 10 minutes. It was witnessed by several diverse employees, and the employee was subsequently terminated for violating company policy. When challenging the termination at arbitration, the union argued that the conduct was really shop talk, which, as we know, historically in arbitrations has attracted, very little discipline. And that's what they argued it was, rather than egregious workplace harassment that justified the termination. Next slide, please. In this case, the arbitrator rejected that proposition and rejected the idea that this was locker room language that was somehow acceptable. In the sexual harassment context, there have been other decisions that talk about how locker room language in that context is also not acceptable. And the termination was upheld, even though the employee had 23 years of service and a clean record. The arbitrator took notice of some gaps in the case law. Next slide, please. And really described what he thought was, the quote was, a regrettably all too slow acknowledgement of racial slurs and microaggression in the workplace and their effect. And this is a quote from that case that talked about the natural evolution of thinking when it comes to eradicating racism in the workplace, and what all employees know or should be expected to know about what behavior is unacceptable, which again goes to the training point. Okay, and I'll turn it over to Catherine to discuss the next two cases.
Thank you, Sarah. This CocaCola case, which is up on the board right now, is a case out of from the Labor Board in British Columbia, and it's about as recent a case as we could find. An incident occurred at the Coke bottling company several weeks after the death of George Floyd, so just a year ago. And in this unionized bottling plant, the employee came in wearing a COVID mask, but embroidered with the Confederate flag and the words, "The South will rise again." A complaint was made about the mask. The employer conducted a relatively brief investigation. Person, admittedly wore the mask. He was asked to remove it. He did so right away. The employer concluded that the wearing of the Confederate flag was a form of blatant racism, and that it was in violation of its workplace policies on discrimination, and the individual was terminated from his employment. He grieved, or the union on his behalf grieved the termination, saying that the behavior was at the low end of the scale of unacceptable behavior. And the union admitted that the behavior was improper, but that termination of employment was too much. And also, importantly, the union said this individual had no intention at all to offend anyone or to go against any policies. I think in reading the case, it looks like the individual in question didn't really understand what a Confederate flag would mean and what a symbol of oppressive racism that was. So the union was arguing intention. We know that intention is essentially not meaningful. It's impact, but that was the argument made. Next slide, please. So the arbitrator reviewed all of the circumstances before him, and the arbitrator concluded that termination was too harsh a response, and that rather a 5-day suspension was the right way to proceed. In part because, and these were all mitigating circumstances, the employee had removed his mask right away upon realizing that it was offending people. He had apologized, not just at the time, but also at the arbitration. It was important for the purposes of mitigation of penalty that he didn't intend to use the mask to promote racism. And finally, there was no conclusive evidence that walking into the workplace with this mask had somehow led to a poisoned work atmosphere. And so for those reasons, termination from employment was changed to a 5-day suspension. And the quote from the arbitrator, from Arbitrator Noonan, is a reminder to us all that workers today must be sensitive to issues of diversity and inclusion, must take care not to act in ways that marginalize, offend, hurt, denigrate, or otherwise discriminate against others. Although I find that the griever did not intend to cause harm, he nevertheless wore a mask that through its symbolism was offensive to the values of Coca-Cola and Canadian society. So pretty stirring and stern language in the bottling case. Another case that we wanted to share with you, Francis versus British Columbia, is also a case out of BC. They seem to move perhaps more quickly than we do in Ontario, but we like this case because it's an important case out of the BC Human Rights Tribunal, where this case got some publicity actually because of the numbers involved. The tribunal ultimately ended up awarding this gentleman just under $1 million in compensatory and general damages. But in this instance, Mr. Francis was a Black correctional officer employed by the province, and he had been singled out, it sounds like almost daily, frankly, for the color of his skin. He was made the butt of repeated jokes of a racial nature. Racial slurs were uttered in his presence frequently. His colleagues suggested that Mr. Francis just couldn't take a joke. That's all they meant. They were just joking around, and that Mr. Francis was overreacting to the jokes, and that he was thin-skinned. The tribunal found in favor of the applicant. They found that he had been stereotyped, singled out, subjected to everyday racism, that management had not, that management knew, not that management should have known, but that management actually knew that Mr. Francis was on the receiving end of this kind of behavior. And the fact that they did not respond appropriately came in the award section. Just recently in 2021, Mr. Francis was awarded, as you'll see, $167,000 in compensatory. Those are damages that compensate him for actual loss that he can prove, and general damages. Those are damages that are for unspecified, but you don't have to show, I lost 2 hours of work, but it's injury to dignity, injury to feelings, injury to self-respect. This was a new Canadian record, that $176,000 for injury. For Mr. Francis, unfortunately for him, being subjected to everyday racism day in and day out, regrettably made his mental health deteriorate to a very significant extent. And so, getting $1 million wasn't really going to compensate him or make him whole. So I think this case is important because it's recent. It's critical of management for not taking an appropriate response. And it's a reminder to us that if we as employers don't respond, that the price that has to be paid, not just Mr. Francis's mental health, which is incalculable price, but also the price that the employer has to pay in terms of these damages. Like that's, if we need a reason to deal with experiences of racism in the workplace, I think this Francis case is a very good one indeed. Sarah, back to you.
Thanks, Catherine. Next slide, please. So we wanted to talk a little bit about the impact that various social movements and this increased discussion is having on investigations. And let's go back to basics for a few minutes in terms of why we investigate. We want to ensure that there's compliance with applicable laws. Next slide, please. We want to make sure that we identify and address any areas of concern in the workplace so that we can build trust and confidence within the organization. And most importantly, we want to be able to create and maintain a strong and positive work environment because we want the best employees. And the only way to get the best employees is to make sure we have a workplace where people want to work and a place that's respectful. Interestingly, a statistic I read recently said that in 2020, millennials make up half of the global workforce. And in a survey of a group of those folks, 86% of the women and 71% of the men said that a company's policies on diversity and inclusion were very important to them when selecting what employer they would work for. So these are key issues and continue to be. Next slide, please. I think in the current environment, maybe now more than ever, employees need to know that they can raise issues without fear of retaliation and that the employer will conduct an investigation that is procedurally fair. If employees feel investigations are somehow biased or unfair, they're not going to bring forward concerns at an early stage where we want to address them. And we're going to have people who are hesitant to participate in the investigation process. So it's very important that we still maintain all the principles of procedural fairness, informed by the dialogue that's going on. So we want to make sure things like we know and follow the investigation policy and procedure. We get a very clear understanding of what has happened before, during, and after any particular incident. And very importantly, a respondent must be given the opportunity to fully respond to the allegations. And very often that means getting notice of the allegations in advance. We want to make sure that all parties you have a discussion with all parties about reprisals. So complainants know to bring forward any concerns they have after they make a complaint, bring them forward to you right away, no delay. And that respondents and witnesses are also aware of the zero tolerance for reprisals and consequences. The key is that it's essential that the investigator be perceived by all parties as being fair and unbiased, and that's all parties. And so we'll talk about that in terms of choosing investigators in a little bit. And there are plenty of cases where damages have been awarded against employers where procedural fairness is not observed. Next slide, please. So as a result of the Me Too movement and the high-profile cases involving allegations of sexual harassment, there's really been a re-examination of some of the underlying assumptions in sexual harassment cases. And this is a re-examination that really started in the context of criminal sexual assault cases some years ago, but it's now continued into the sexual harassment context. And again, this is a really important point. It doesn't mean that when we're conducting investigations, we don't ask the questions, right? But we need to be mindful of how we ask the questions, especially when we're dealing with allegations of assault or sexual violence, and think about the evidence gathered and our conclusions in a way that doesn't adopt invalid assumptions where those assumptions are not valid. In terms of misconceptions, one thing I think as employers we've all dealt with is the heightened expectations of complainants. We have complainants who have seen very high profile cases in the media where people are immediately fired and sort of disappear out of a workplace. And so they may have an expectation that this process is going to be very quick and someone's going to be fired right away. So we need to make sure that employees are educated about the process and that they understand that there is a procedure that will be followed. Keeping them informed is key to that, but be mindful of the fact that they may have an elevated expectation because of what they've seen in the media. A couple of areas just to highlight, because I want to be mindful of time, is there are cases about relying on what you think a sexual assault, for example, victim, how they would be expected to act, and what assumptions or conclusions you can draw from that. And courts have found that you can't rely on what is presumed to be expected conduct. An arbitrator in Alberta was called to task for explaining how someone who had complained of a sexual assault didn't appear to act in a way that she had been traumatized in any way right after the incident. And the arbitrator was called to task for this outdated expectation about how people will behave after. Similarly, there's lots of studies that talk about how a delay in coming forward shouldn't form the basis of an adverse inference regarding whether something actually happened. There could be many reasons for that delay, including fear of reprisal. There are cases where courts have pointed out that investigators really need to consider things like power dynamics between the parties and make sure that they keep in mind that witnesses to incidents between individuals, for example, when there's an allegation of sexual harassment, the witnesses may be of limited use because it may have appeared to be consensual in that instance where it wasn't in other instances. There is a lot of literature about trauma-informed approaches to investigating sexual violence. So if you're involved in investigating an area where there is sexual violence involved, just maybe do some reading, get some expert advice on this. For example, investigators are instructed that they should really be conscious of how many times a complainant is required to repeat their story, because there can be issues for the individual if they're forced to retell the story. So again, this is really just a list of some examples of things to be mindful of. Again, I'm not suggesting you don't ask the questions or explore the areas. You just be mindful about how you do it and whether you're adopting some of these misconceptions without evidence. Next slide, please. I'll leave you to read this slide for yourself, but this was an example of a case where the Court of Appeal talked about a trial judge's irrelevant stereotypical views about behaviors and responses to sexual assault as an example of how courts are, how the discussion, even in the court context, is changing. Next slide, please. So in terms of the impact on workplace investigations, these are some of the trends that we've been noticing and some of the things that we're seeing reflected in the literature. So the common understanding of what is discriminatory is changing, as we mentioned at the beginning of the presentation. So we are seeing complaints about comments that could be characterized as microaggressions or allegations of unconscious bias, and an increased awareness and discussion of issues of systemic racism, for example. As Catherine has mentioned, and I mentioned before too, a key is to make sure that your employees, your HR staff, your investigators understand and are trained on these concepts. Because as investigators, we need to understand and make sure we're considering and are being aware of them. And it's very important to engage in active listening with this in mind. So where a complainant might say that an workplace is toxic, for example, it's very important to engage in active listening and question and understand how the environment is toxic to them. And then you can make a conclusion ultimately about whether it's toxic or not. In terms of public relations, in some instances, we have complaints and someone raises the issue in a Facebook post and they get, 10 or 20 responses. And companies are saying, what can we do to shut this down? Should we shut this down? And very often the advice is just leave it. If you respond, those 20 responses are going to multiply. It'll live and die its own life. But we are all completely aware that there are many more high profile cases, and social media campaigns are such that public relations and even crisis management becomes a key issue in these cases. And they get the attention of boards and very senior management. So I think it's important for us to be mindful when we're dealing with these workplace issues to make sure we consider whether we need some sort of public relations or crisis management. The next point on the slide is our role as the independent fact finder. It's very important that even though we are aware of the evolving dialogue and increased commitments to diversity and inclusion, that we remember what our role as investigators is. And that is, we're an independent investigator. We are an independent fact finder. We need to keep in mind that there is a difference between an allegation and a substantiated allegation. And there can be a lot of pressure on investigators in this area to believe a complainant. But our job is to make sure that we investigate that allegation and come to a reasoned finding of fact. And notions of procedural fairness, as I've mentioned before, really still apply and have to apply if employees are going to have confidence in your process and if you want to have a legally defensible claim. One trend that we're seeing is employers investigating older complaints that previously they may have chosen not to investigate. And I think that is done with the recognition that there are difficulties in investigating older complaints. It's part of the reason we have statutes of limitations. Evidence is lost, witness testimony can be unreliable. But generally, when Catherine and I were discussing this as investigators, we've really found that most employers are trying to investigate even older claims. It can vary in a particular individual case, but generally what companies are trying to do is collect the evidence that is available and then evaluate the reliability and credibility of that evidence and make findings. The other thing that we're finding is a trend to investigate allegations that may not just be a violation of a harassment policy, for example, but a broader policy like a code of conduct or particular conduct that might violate your expectations regarding someone's performance in a managerial role. So we're seeing older complaints being investigated and a broader brush being taken to what would be investigated. And again, it's very important to think beyond your own perspective and incorporate some of the ideas that we have been talking about today when you're conducting these investigations or supervising them. Next slide, please. Another thing that we've noted is there can be some impact on the interviews that you're conducting or that are being conducted during an investigation. We're seeing more complaints, and we think that's because there's less reluctance to bring forward complaints, as well as to bring forward a broader range of complaints. So as we've talked about, that active listening is very important. We're seeing an increased awareness of retaliation, probably because of the great deal of discussion in the media about retaliation and fear of retaliation. So employees feel more liberated to talk about their fear of retaliation or to bring forward complaints. And then we don't want a process where respondents feel that there's going to be a rush to judgment and they're going to be fired no matter what. Everyone needs to feel that this process is fair. There's plenty of instances where neither the complainant nor the respondent will agree with what you've done, but we do want to maintain that procedural fairness. The goal is overall balancing our promptness and thoroughness with that need for impartiality and fairness and no rush to judgment. So with that, I will turn it back over to Katherine for some key takeaways, and then we'll turn to questions.
Yeah, it looks like we've got some really good questions as well. So I won't be too long with the key takeaways. But the overarching comment that I wanted to make is that here we are in 2021. We're in the midst of huge social movements, Black Lives Matter, Me Too, the emergence of microaggressions. There's obviously a long list. But what's not changed as of 2021 is that our role as investigators is to ensure fairness to both the complainant and the respondent, regardless of the circumstances or whether the culture has something to say about what the accused has been accused of. We can't rush to judgment. We have to adopt that fairness as we always have. That said, though, it is incumbent upon us all to recognize these social movements, that the impact that they have in the workplace, to be aware of everything from cancel culture to microaggressions to unconscious bias, to understand that the law is evolving each and every day and that it's incumbent upon us to make sure that we're abreast of those developments. That we are educated and knowledgeable about what's going on in the world at large, because that's what employees will be complaining about. We are definitely entering into an era where investigations are under increased scrutiny, in part to make sure that investigations are fair and that there has not been a rush to judgment. It is absolutely key that independence of the investigation is safeguarded. To the extent that there's a delay, be prepared to explain that delay both to the complainant and the respondent, and perhaps in your report as well. As Sarah said, we really cannot be rushed to judgment. There may be intense pressure from a board of directors or from management to move this along because it's a very high intensity allegation or a well publicized allegation. You can't rush these things. Fairness dictates that it not be rushed, but at the same time, you need to explain delay. All key witnesses must be interviewed. No shortcuts. All key documents have to be reviewed. And if for some reason you can't interview a witness or there's a key document that's not accessible, make sure you're talking about it in your report as to why that is. And finally, just on that point about the report, this was Sarah's remark yesterday when we were preparing, and it's a good one. What would you like your file to look like if it were produced to a third party? It's just a reminder to us as investigators to make sure that we've got everything in the file, that it's properly organized, that it's clear what has been collected, what has been analyzed, what you have concluded about witnesses and their credibility and why, and finally, how you have reached your reasoned conclusions. As I say, none of that's changed in 2021, but perhaps investigations are a little more under scrutiny. Next slide, please. Really important to make sure that your workplace policies are up to date. Kathy's already referenced the workplace policies under the federal regime, and I know we've got some questions coming in about that. I've seen them in the chat. But make sure your workplace policies are up to date. It will often be the case that I'm called in to investigate, asked to see the policies on point, and they're a little on the ancient side, and they don't reflect the reality either of the laws that exists in any of the jurisdictions in Canada, or don't reflect the workplace. So just make sure that it's a standing order, that your policies are kept up to date. And Sarah, Cathy, and I are talking about this a lot today, and it really, really is key, not just for you as an investigator or as an employer, but to make sure that your employees, particularly those in positions of authority, in those of positions of hiring, are undergoing training on unconscious bias, on microaggressions, on the expansion of what discrimination means in this day and age, in the middle of 2021. And finally, be mindful of stereotypes in investigations, not just your own stereotypes that you may have in mind, but when you're meeting with the complainant or with the respondent or with witnesses, make sure you're getting at the facts upon which people are relying and not just stereotypes. So those are some key takeaways. We've left 15 minutes from 3:15 until 3:30 Eastern to go through some questions that have been have been coming in. Sarah, I know you've been keeping track, so I'll ask you to go ahead and moderate that, please.
Thanks, Catherine. The first question that we've got is a question for Kathy regarding the federal update. And the question was, does the designated recipient have to be an employee in the workplace?
Oh, thanks, Sarah. So the designated recipient, just as a reminder, that's the individual or the work unit that's going to receive the notice of occurrence. So no, they don't have to be an employee in the workplace. As I said, I think typically they probably will be. It'll probably be an HR department, a labor relations department, but certainly an employer could decide to retain a third-party organization to act as a designated recipient. I think the takeaway here, though, is that whoever it is, internal or external, they should have no direct personal relationship or working relationship with the parties that are involved in the occurrence, and whoever it is should also obviously be able to protect the confidentiality and privacy of the parties to the extent possible as well.
Okay, thanks, Kathy. Let's look at some other questions. Well, this is a good one. Catherine, someone's asked about, could we speak a little about the difficulties in reconciling the objective work of the investigation with the emotions and perceptions of the parties and having the objective conclusions of the investigation accepted by them? Could you talk a little bit about that?
Thanks, Sarah. That's really important, and it sort of links back to what we were talking about a little bit, the importance of the investigator not just being objective, but also being perceived to be objective. So I think it's fair to say that at the conclusion of most investigations, one or sometimes both parties are not happy with the conclusions, and just think, Catherine Pollock didn't understand what I was going through, and there is emotion as a result of that. But I would hope that either upon reflection or with later reflection, that the individual could see that the process that was followed was fair, that the individuals in question were heard and understood, that active listening, and that even though the conclusions arrived at might not accord with that person's view, that at least that individual could be confident that there was a fairness to the process. But there's no doubt about it that it's very difficult and impossible, I think, to strip the emotion out of it, but to try to be as objective as possible, just the facts, avoid stereotypes, and just focus on the objectives. I think that's all that can be asked of an investigator.
Thanks, Catherine. We're getting quite a lot of questions about harassment investigation procedures. This is one question. Maybe Kathy, you could take this one. Should we interview witnesses separately, or is there some use to interviewing that group or those people in a group? Could you talk about that for a few minutes?
Yeah, sure. Thanks, Sarah. So I think I think here it's important to start off by saying that the interview process is a really crucial process to having a fair outcome. And if it's performed poorly, then it can lead to some serious consequences for a company, right? Including inaccurate findings, allegations of bias, wrongful dismissals, and even other legal proceedings as well. So all that to say that you should definitely interview one person at a time. People should be interviewed individually, not in groups. Certainly, things like group dynamics or peer pressure can obviously distort or suppress responses. Some people might feel very intimidated in a group context, and you definitely wouldn't be able to maintain confidentiality, and that's a key requirement when you're conducting investigations, as we've been discussing. I mean, even when interviewing parties one-on-one, investigators need to take steps to ensure that all individuals understand that confidentiality is essential to the process. That, although it can't be guaranteed, confidentiality doesn't mean anonymity. Information obtained during interviews needs to only be disclosed to parties on a need-to-know basis.
Thanks, Kathy. We've got several questions in the Q&A about procedure around Zoom interviews. And maybe, Catherine, you and I can talk a little bit about this. So questions like, can we set an expectation that people have their cameras on? And are there any steps we can take to ensure that people aren't being coached when the interview is actually taking place? And just as an aside, we had a colleague who was conducting an interview and heard sort of whispering off on the side with the fact that they concluded that there was someone there who was assisting or providing, some hints when the person was responding. And when asked if there was anyone in the room, the person said there wasn't. And then the response was, well, I can hear them talking. And then very sheepishly, the guy's girlfriend crawled out from under the table where she had been hiding and left the room. So, that's probably an unusual situation, but I think your concern about how do we ensure that people, aren't being coached by others on Zoom. What about the expectation of having people have their cameras on? Catherine, do you have any thoughts on that?
Yeah, I think it's entirely appropriate to set expectations, and I would want the camera on, unless there's some good reason for it not to be on, and I'm not sure what that good reason would be, because I do think it's important it's important to see what the individual is doing, and I don't mean those nonverbal cues when trying to assess credibility, but I mean just literally what is that person doing. So I think it's entirely appropriate for the investigator to set some parameters, to get an assurance from the witness that he or she is alone. Now, if somebody's going to be devious and have his girlfriend, under the desk, there's not much that one can do to guard against that. But my point is that I believe that you can certainly set expectations and standards and expect people to follow them.
Yeah, I completely agree with that. We've had another question that's an interesting one about what about anonymous complaints, and do we investigate anonymous complaints? I mean, I'll give my thoughts, and then Catherine, if you have anything to add. I think many employers, because they want to have different avenues of complaint available for people, will provide some way for people to leave an anonymous complaint. And very often I've seen policies that say, if you leave an anonymous complaint, it's helpful to add, some information so that we can follow up on it. But I think similar to the idea of the older complaints, we would suggest that you try to investigate those complaints. You're offering an anonymous way to leave complaints for a purpose, so you don't want to ignore them. And see if there is enough information in the complaint that you can use as a jumping off point for your investigation. If there's absolutely nothing that would cause you to be able to identify, the parties Some people have considered doing some touch bases with employees in different departments to get a feel to see if there's an issue. But generally, if an anonymous complaint has been made, especially if it's on a forum that you have provided, I'd suggest you do the best you can and investigate with what you have. Catherine, any thoughts on that?
No, I would agree, Sarah. And I think that to me is a big change in the last few years. It used to be that we just would not go near anonymous complaints because the feeling was, especially if it was a complaint about a specific manager, for example, that it was very unfair to that manager not to know who was accusing him or her of misbehavior or discrimination or whatnot. And that it might be easy for somebody under the cover of anonymity to make outrageous false claims. But that was then. This is now. I think it's very fair to say that on average, most employers will want there to be that avenue so that you can get at any underlying issues that might be there. And sometimes the only way it's going to percolate up is through an anonymous complaint. What's uncovered as a result of trying to investigate, it will be what it will be. And it will often, this is similar to what you just said, Sarah. I often see employers say, maybe we'll do a pulse survey or something like that just to get at, are there issues here that we need to be concerned about? Because we really would like to nip those in the bud, so to speak.
Thanks, Catherine. We've got another question that came in about ghosting, which is kind of interesting. So the circumstances that they talked about is one employee ignoring all emails from another employee in group settings because the person doing the ghosting may feel that this employee is too toxic to interact with, or the person who's being ghosted may feel that they are being ignored or harassed. That's an interesting question with this whole concept of ghosting. And I think the short answer is you as the employer probably have a duty to do something in both those instances. So where there's someone who is choosing not to interact with someone because they feel they're being toxic and you become aware of this, you need to understand what is it that this person's doing that causes others to conclude they're being toxic to the extent that they don't even want to interact with them. So I think that's the first point that comes to mind. The second is sometimes we see this issue of employees being ignored or frozen out or something like that after they've made a complaint. And as employers, we have to be very vigilant about that because that conduct can be seen as retaliatory. So you may have done an investigation and found out, concluded, for example, that there was no underlying discrimination, but now this behavior can set you up for another independent violation of the Human Rights Code, for example, of engaging in retaliation. So if the employee who is being ignored or ghosted has recently made a complaint, I'd look into that situation a little bit more because there's a possibility that there could be a retaliation issue going on. We see this sometimes where employees are just frozen out by their colleagues, don't deal with her, you'll end up in HR. And that really can be seen as bullying independently, or it can be seen as retaliation. So I think you'd need to pay attention and dig deeper into those circumstances to find out what's going on. Catherine, anything to add to that? That's a good question.
Sarah, right. I think that's a really good question. It just reminds me that if we had been doing this presentation 5 years ago, ghosting, microaggression, and unconscious bias would probably not be on any of our slides. But I completely agree with your answer.
Well, I'm looking at the time and I want to be mindful of everyone's time so that you could all get to your next appointments. On behalf of all my colleagues, I really want to thank you all for attending. We wish we were all sitting around in a conference room with you so we could engage in some real good discussion and debate about these topics, but we'll make do with this forum. Thank you for the great questions, the ones that came in during the presentation and the ones that came in before. And I just wanted to remind you that we'd really appreciate it if you would fill out the survey after today's presentation. It's helpful to us picking other topics and making sure that we're giving you the content and the topical information that you want. And I've been told that you will need to refresh your page in order to access the survey link because it wasn't available as soon as you logged in. So if you're going to do the survey, which we'd appreciate, then please just refresh your page in order to access that so we get that feedback and suggestions for other topics. And if you'd like to have a longer seminar on this where we grapple with some of these issues in investigations, then let us know that too in the feedback. So again, on behalf of all my colleagues, thank you very much for your attendance and your input. And we hope you all have a great day. Thanks very much. Bye-bye.